You're watching The First TV. This is Josh Hammer, host of America on Trial with Josh Hammer, a First TV podcast. And we are here with some massive breaking news, so you might have heard. I mean, this is the day that we have been waiting for a long time. Those of us who are in the legal commentary business, who are in the political commentary business, those of us who are lawyers, those of us who talk a lot about lawfare, talk about the weaponization of the justice system, the weaponization of the judiciary, the weaponization of all things political and legal related. This is the day that we have been waiting for over a year. Now, in many ways, today's outcome, in which former President Trump has been found guilty on all 34 counts, by the way, 34 counts of an underlying New York State misdemeanor whose statute of limitations told all the way back in 2018. We can get to that in just a little bit here. In many ways, the outcome today seemed preordained. If you go back and think about how this whole sham process started, when Alvin Bragg, the Soros-funded hack prosecutor in New York City, when he campaigned for his office, literally campaigned for office on the campaign trail, saying that he was going to do everything in his power to get Trump and to put him behind bars. This is a man, Alvin Bragg, who has presided over a skyrocketing surge in violent crime and property crime alike in his jurisdiction in Manhattan. He doesn't care. He doesn't care that people are getting mugged on the subway. He doesn't care that people are getting stabbed left and right, that shootings are up, that burglaries are up, that robberies are up, that people are afraid to ride the New York City subway. Alvin Bragg doesn't care about that. He campaigned for this office. He campaigned for New York County, New York DA to get Donald Trump. So from that perspective, when he dropped this indictment in March 2023, many of us knew what was going to happen. The Rubicon really, in many ways, was crossed a long time ago. The Rubicon was crossed when you campaigned for office in that particular way. You know, there's an obscure constitutional provision that prohibits what at English common law was known as bills of attainder. Well, what is a bill of attainder, you might ask? A bill of attainder was the old practice that the British Crown engaged in and Parliament way back in the day before various reforms to the old British legal system. We're talking like 400 or 500 years ago. A bill of attainder was a piece of legislation or a piece of monarchical edict, essentially an order just from the king, that singled out one person. In other words, this was not a neutral law, the bill of attainder. It was going after the man, not the action. Fast forward a few hundred years, this is also what Joseph Stalin, the infamous Soviet mass murderer, is that also exactly what he was getting at when he famously said, quote, "Show me the man, I will show you the crime." It was technically Stalin's henchman, but it's popularly attributed to Stalin himself. The U.S. Constitution prohibits bills of attainder. I'm not going to do a legal discourse here on bills of attainder, but you get the idea of what I'm saying here. The idea that our justice system works in such a way that we do not target actions, that we do not neutrally enforce laws, rather we go after specific individuals, is literally as old as the Republic itself. The prescription on bill of attainder was not there in an amendment. It was there in the original Constitution, right there in Article 1. So Alvin Bragg drops this indictment over a year ago. He campaigned in bill of attainder-esque fashion. Every step of the way, every single step of the way, this trial has been a farce, the likes of which I have never seen in my entire time following law and politics. You have the fact, first of all, that the indictment was even brought in the first place. Alvin Bragg's predecessor, Cy Vance Jr., his predecessor there as New York County, New York DA, he also looked into these charges. He also declined to bring it. How about the federal prosecutors there? The U.S. Attorney's Office, the SDNY, the Southern District of New York. They also looked into this, and they declined to bring charges as well. Alvin Bragg, of course, has no such compunctions because he's a Soros-funded hack. So you have the indictment, you have the pretrial proceedings there. Turns out the judge is Juan Merchan. But what is there to say about Juan Merchan that hasn't already been said? This is a man who personally donated to the Biden-Harris campaign in 2020, has no such compunctions about that. This is a man whose daughter, Lauren Merchan, works for a company you may or may not have heard of called Authentic Campaigns. Who is Authentic Campaigns? Authentic Campaigns is a Democratic fundraising and consultancy vehicle. It is a company that exists for the sole and exclusive reason of raising money for Democratic clientele, elected officials, candidates, people like that. Laura Mershon, the judge's daughter, raised $93 million, roughly speaking, based in part off of the promise that her daddy would lock up Donald Trump and become the first man to do that. Over the entire course of this sham Stalinist proceeding, this trial, the judge acted in the most biased fashion possible. He totally prohibited the Trump lawyer's choice for expert witness, Brad Smith, the former Democrat-nominated FEC Federal Election Commission commissioner. He prohibited Brad Smith from being able to testify about substantive campaign finance law. He only said that if you Trump lawyers, if you're actually going to go up and then call this guy, Brad Smith, to the witness stand, he can only do kind of a 35,000-foot altitude view, more of an explanatory sermon where he just explains what the FEC is. By the way, total sham in the first place that we're talking about the FEC and federal campaign finance law in state court. They have no jurisdiction even bringing these federal charges. Doubly so when the federal prosecutors at the SDNY, the Southern District of New York, when they literally looked into it and they passed. Now, after the indictment dropped, you had 34 counts of fraudulent bookkeeping in New York State. That is a misdemeanor. It is not a felony. It also has a statute of limitations of 2 years. That told all the way back in 2018. Alvin Bragg has purported to get around the statute of limitations issue while simultaneously elevating this misdemeanor to a felony. God forbid he actually prosecute a real felony, a mugging, a carjacking, a gangbanging, a murder, a rape, a this, or that. He has no interest in doing any of it. Don't just take it from me. My brother lives in Manhattan. He and his wife will never get on a subway car for the foreseeable future. Not while this man, this degenerate, this disgrace to the American Republic, this absolute monstrous disgrace to the Anglo-American legal system. They're not getting on a subway while he is calling the shots. But Alvin Bragg's indictment tried to get around the statute of limitations problem while getting us from a misdemeanor to a felony, while not even saying how he was doing so. That was my very first thought as a lawyer myself when I read the indictment over a year ago now. What is the legal theory of the case? How in the world are they purporting to get around this statute of limitations issue while getting it from a misdemeanor to a felony? Well, they're saying that's a fraudulent bookkeeping charge in furtherance of what exactly? We were never told this. We were never told this throughout the entirety of the pretrial proceedings. We were never told this throughout the entirety of the trial itself. I, like all of you, literally learned the prosecution's theory of the case this week. I literally, personally, I cover this every day, folks. America on Trial with Josh Hammer. Tune in, listen to my podcast right here with the first. I learned what the prosecution's theory of the case was literally this week when I read the same jury instructions that you probably read. Well, what were those jury instructions exactly? Well, it was a convoluted mess, is what they were in short. It was first-degree fraudulent bookkeeping charge. Now, a first-degree fraudulent bookkeeping charge under New York State law means that you have an intention to defraud someone through some undefined unlawful means. But what are those allegedly unlawful means? This is kind of the in furtherance of crime that many of us have been looking to ever since Bragg dropped this 34-count indictment over a year ago. What are the unlawful means under the fraudulent bookkeeping statute? What is the in furtherance of tack on, the predicate offense, to use the proper technical legalese here? Well, in the jury instructions, which came out 36 to 48 hours ago, we finally learned what those predicate offenses were. They gave us three possibilities. As many of us expected all along, there was a federal Campaign Finance Act violation. Put another way, the allegation was that Donald Trump's or his Trump organization's payments, the alleged payments, they never even confirmed, but the alleged payments to Michael Cohen to reimburse him for the Stormy Daniels hush money payments, that was actually a campaign finance contribution. By the way, as I said, Alvin Bragg has no jurisdiction to even bring a federal campaign finance violation. But nonetheless, that was one of the three suggested unlawful means. What were the other two? The other two was a federal tax law violation. Well, same problem. Alvin Bragg similarly has no jurisdiction to bring a federal tax law prosecution, the same way that he has no jurisdiction to bring a federal campaign finance law prosecution. And then the final unlawful means, as stipulated in the jury instructions, was an additional fraudulent bookkeeping charge. In other words, there were three separate unlawful means. And as Judge Merchan told us yesterday, in what Jonathan Turley referred to, as it turns out, presciently, as the coup de grace for Donald Trump and his defense, Merchan made clear that the jurors could disagree among themselves when it comes to what that unlawful means actually are. It didn't matter whether all of them thought that it was a campaign finance violation, that all of them thought that it was a tax law violation. No. Four of them could have thought that it was a tax law violation somehow. I honestly don't even know what that theory is. I genuinely don't even actually purport to understand how any of this amounts to a tax violation. Four of the jurors could have agreed to that. Four of the jurors could have somehow agreed that it was an improperly recorded campaign finance contribution. And four of it could have agreed that it was a second undefined fraudulent bookkeeping charge. Folks, in criminal law, your first year of law school, you learn very clearly that for every criminal act, you need a unanimous jury when it comes to the two overarching elements of any black letter criminal statute in this country in the Anglo-American legal order. Actus reus, which is the physical act, that would be the pulling of the trigger in a homicide, and the mens rea, the subjective mentality. Where in the world was that in these shambolic jury instructions? Where in the world has any of this intellectual honesty, any of these scruples, any of these norms, decorum, procedure, where has this been throughout the entire course of this sham Stalinist proceeding? You know, the left likes to say that Donald Trump and Republicans and the American right in general, that they are the threat to our democracy. That would be our democracy, which they disingenuously claim to actually love, while they simultaneously fund the civilizational arsonists, the BLM, Antifa, street thugs, and so forth, who try to burn it down. Who is the actual threat to our democracy here? The left tried to get Donald Trump kicked off the ballot, lest you recall, using the Section 3 of the 14th Amendment insurrection clause theory. That theory, which liberal commentators gobbled up like it was mother's milk, which the disgraced former Fourth Circuit appellate judge J. Michael Ludig said was an ironclad theory. It was fail-safe. Well, that thankfully was rejected at the Supreme Court 9-0. So the folks that say that Trump is a threat to our democracy first tried to kick him off the ballot, the literal ballot, like the most democratic thing imaginable. And then, of course, they prosecuted him in 4 separate jurisdictions, 2 federal probes, 2 state probes. And now they have become the first hacks. And hacks is what they are. The first hacks to successfully convict a former president of the United States. The Rubicon has been crossed. It is a dark, dark day for the American Republic. And anyone at this point who says that Republicans just have to sit and take it. Oh, we're better than them. Oh, we don't get our hands dirty like that. Oh, I just want like a neutral playing field, like liberal neutrality. Screw that. Wake the heck up and understand what is going on. You absolute dolts. If this is not a 5-alarm siren wake-up call for the American right, for Republican DAs and prosecutors all across this country, if frankly, of the past year and a half, has not already been that, at least ever since the pre-dawn raid at Mar-a-Lago in August 2022, which led to Jack Smith's classified documents federal probe. But at bare minimum now, if you are not waking up tomorrow on Friday, May 31st, and you are not smelling what the heck is going on here and how rancid and fetid it stinks, I don't even know what to say at this point.